Good afternoon, dear ladies and gentlemen, dear colleagues. It's my pleasure to introduce Mr. Ketan Modh to you. Ketan is Marie Curie European Research Officer at the University of Malta. He holds a double degree on information policy and governance from the University of Malta on the one hand, and the University of Groningen in the Netherlands on the other hand. And he has been working as an assistant to Professor Joe Cannataci, who some of you know, certainly also as one of the guests we had already in this podcast. Joe Cannataci was UN Special Rapporteur for the right to privacy for 6 years, and he has been working as a professor at the University of Malta and also at the University of Groningen. And Ketan has been working quite closely and intensely with him. This is also the reason why we know each other, because both of us have cooperations with Professor Cannataci. We met for the very first time some weeks ago in person, and we have we know each other, but we don't have any project or something running at the moment that would trigger any transparency issues or confidentiality issues or whatsoever here. So it will be a very open debate on that we are going to have on two very interesting subjects to this podcast. Obviously, the first one is privacy in COVID, and the second one is India, because Ketan is working in Malta, but he is of Indian origin, and obviously he's monitoring the situation in India quite closely. So what I'm hoping to learn from him is about how privacy in India is dealt with in general, and then in particular during COVID. That's what I would like to take with me in this session. Ketan, so warm thank you for your time and for making yourself available for this. I think that if someone with an Indian background is confronted with Europeans, you are probably a little bit tired of all the same naive questions coming all the time, but they will probably also come now. So thank you for your patience right in advance. Perhaps let's start very briefly with, is there anything such as privacy in the European understanding within the Indian legislation? And if so, how does it look like?
Good afternoon, Nikolaos, and good afternoon to your audience as well. I'm glad to be here. Thank you for inviting me. Before answering your question, perhaps it would help if I also give a bit more of a background of myself in relation to India. So I am a lawyer. I completed my law degree at the National Law University, Jodhpur, which is one of the premier law institutions in India. After which I worked as a contract lawyer, basically negotiating and drafting contracts for software licenses, etc., which had privacy as a component, of course. After that, I completed my master's at Leiden University in law and digital technologies. Following which, I started working towards my PhD, which I just recently completed. One PhD at the University of Malta and the other at the University of Groningen, as you mentioned. And that was where Professor Cannataci was one of my supervisors. So that is roughly my background in privacy and with India as well. To touch on the issue of privacy as it relates to India, to be perfectly honest, pre-2017, there was no real conception of privacy as a fundamental right in the country. It was read into the Constitution of India. So I'm sure your audience might also be aware, but India is a common law country. It's not a civil law country. We do have an extensive constitution, but one that never mentions privacy anywhere. What it does mention is the right to personal liberty in Article 21 of the Constitution, which was the article that was expanded. The interpretation of that article was expanded by the Supreme Court in 2017. That's the first time that the right to privacy first came about in India. Having said that, there were data protection rules in India since the early 2000s. But these are data protection rules, not privacy rules. So there is no omnibus legislation that deals with privacy in the country as of yet. That might change soon, however, because following that 2017 judgment, there was another judgment in 2018 that talked about the Aadhaar card, which is the Indian National Identification System. which was approved, which was considered to be legal by the Supreme Court of India. And following both of these judgments, it was decided that the need for a draft Indian privacy bill had arisen. So it was then in 2018 that the first draft of the bill was proposed, which was then revised in 2019 as the Personal Data Protection Bill. Following this bill, a joint parliamentary committee had been instituted, which basically looked at that bill for 2 years before releasing its report in the end of 2021, I believe, where they recommended many changes to that bill. And that bill is the most current document that the report on that bill is the most current document we have now. It is possible that the bill might be adopted, but what I think is more likely is that a completely new rewritten bill is going to come about, just because the number of changes that were recommended in that joint parliamentary committee report were so extensive that it just made sense to rewrite it all. From a European perspective, it's pretty easy to see the similarities between the Personal Data Protection Bill and the GDPR, actually. It could be said that the Indian bill is just an extension of many of the ideas that are in the GDPR. For example, all the basic principles, data protection principles, the legitimate bases for processing personal data. There are small changes like this, but of course, some of your audience may have also heard of the fact that India has been pretty aggressive with its data localization policies, which basically means that in the bill itself, there are far more clauses that restrict the processing of personal data outside of India than there are, say, in the GDPR. So those are some of the basic ideas around privacy as we understand it in India that are similar to the European perspective.
Yeah. Ketan, if I may I ask 3 very basic questions on this already now? The first one would be, would you draw the distinction between privacy and data protection in a way similar to the distinction as it is drawn in Europe, and in particular in Article 7 and Article 8 of the Charter of Fundamental Rights of the European Union? First question. Second question, do you then, if it's so similar to GDPR, also have an independent authority, and what exactly is the role of the independent authority in the game? And the third one, the third question is probably the most complicated one, because one of the funny things of GDPR, as you know, is that GDPR doesn't cover a lot of very sensitive data processing in the very moment when it's coming to police and justice affairs and secret services and so on, because they are either not regulated at all on a European level or they are regulated in the directive. So is this bill also applicable to anything which is police related, state related, surveillance related? That would be the third question.
So to answer your first question about the distinction between privacy and data protection, I would certainly draw that distinction myself as well. And I believe the Supreme Court has done that as well. Because it read into the Constitution the right to privacy as going beyond the right to simple data protection. And I do think that the Personal Data Protection Bill does that as well. It doesn't talk about the right to privacy. It talks about data protection specifically. So that's the first one, that yes, the distinction does exist also in India. The second one about authorities. So there is a single authority that has been created by the person that would be created if the bill is passed, which is the Data Protection Authority of India. And it is a pan-Indian authority that has actually several powers that go beyond any authority in Europe. Because if you look at the Personal Data Protection Bill and the new Data Protection Bill 2021, you will see that a lot of arbitrary, one might call it arbitrary power has been given to the Data Protection Authority to decide what kinds of processing can go ahead in India. So to give you an example, Something that is unique to the data protection bill in India is this idea of critical sensitive data, critical personal data, which does not exist in the GDPR. And the idea of critical data in this case is that no critical data should be processed outside of India unless it has been approved in certain specific cases. So in that sense, the definition of critical data is actually given as anything that is notified by the government as being critical. There is no real definition to it, which you can understand gives a pretty broad power to the government and to the data protection authority when it comes to ideas like critical personal data. There are other parts of this. So, for example, when I talked about the data fiduciary, there is another level beyond that in the bill, which says, which calls it significant data fiduciary. And there are more restrictions and more responsibilities on the significant data fiduciaries than there are on regular data fiduciaries. And in order to be assigned as a significant data fiduciary, this is something that is within the power of the Data Protection Authority of India. So once again, another power that rests in the DPA that does not rest in most European authorities in this sense. There are several more powers that are granted to the DPA and several carve-outs as well. So for example, the DPA could carve itself out of most of the exemptions and most of the protections under the data protection bill. This is one of the chief criticisms of the bill, including what has been proposed by the Joint Parliamentary Committee, which is the significant amount of power given to the government and the significant exemptions and exceptions granted to the government and government agencies, which actually brings me to the third question about the police and law enforcement. So this is in fact an exception under the data protection bill. Any competent authority that is engaging in law enforcement will not be governed by the data protection bill. So there won't in fact be a law that governs that kind of data protection anymore, or rather there isn't one anyway, and there still will not be one if the data protection bill is passed. We do not have anything that is similar to the law enforcement directive that is being considered in India right now. I hope that answers all
so that is
questions.
a rather, that is a very important answer in a way, because that makes it very difficult to assess the data protection situation in a country if there is no supervision of the state side of the game. And that makes it also very interesting, in my view, that from a European perspective, people are so much aware of anything happening in the US, that we have been debating on this for many years now, Schrems 1, Schrems 2, Schrems 3, Privacy Shield, and all this, Safe Harbor, and so on. And when it comes to other huge areas of the world that are equally important also from a European perspective, because quite some data from Europe is processed, as you know, in India, it is very remarkable that there's so little supervision and so little knowledge about that also in Europe, right? So
actually, that brings up an interesting issue, because from my reading of the bill and talking to other people who are knowledgeable in the field, it seems pretty clear that the reason why the data protection bill was structured in such a way that pretty similar to the GDPR was to entice the European market, really. And through the European market, then the rest of the world. Because I think one of the reasons why the bill is the way it is because of that adequacy regime that is going on in Europe. And there is something similar that would happen if the bill is passed into law in India as well. As I talked about the critical personal data bit, the processing of critical personal data. One of the ways that any non-Indian entity could process that data is if it was approved as having an adequate amount of protection. in other words. So, this is something that is similar to what Europe is doing, similar to what, say, the US is doing through the Cloud Act. And I think one of the key goals of the Indian government in passing this law in the future would be to create this sort of multipolar adequacy regime, but still trying to woo foreign money essentially into the economy in India. So this is interesting because even though India is such a huge part of the market, we still, the Indian government still has a view towards the non-Indian market. So which should be interesting also for European commentators.
Yeah, it's also interesting because this concept of how do you call it, critical personal data, the one that should not be processed outside India, that also looks a little bit like an issue more of digital sovereignty to me, or digital security than data protection, or purely data protection. It reminds me a little bit of the Russian approach, the pre-war Russian approach, also indicating that sensitive things should also only stay within Russia and not leave Russia. So that would also very well fit into this picture that you're drawing here, that this is also something which is about sovereignty, and it's about government interests of becoming a global player in the data market more than protecting fundamental rights of your citizens, right? Would you share that impression?
I would. I completely agree with you. And this is actually borne out even more through some policies that the government has come up with in the last couple of years. So, for example, there is this data access and data processing policy that the government came out with in 2021. And the objective of this policy is to make government data more accessible for economic exploitation, essentially. So they are, in fact, trying to come out as a global player, and they want to use the data that is collected in India to its maximum potential. I also agree that this is somewhat similar, somewhat in line with pre-war Russia and even China, in the sense that there is this view towards data sovereignty and just this idea that the first ones to exploit Indian data economically should be Indian governments or Indian commercial entities. So yes, that absolutely exists. But of course, and perhaps you'll agree, the basis for this sort of thinking comes from European and the US practices. The GDPR is quite limiting in the sense of unless the EU approves of any other country as having adequate protections, as in the case of Privacy Shield, Schrems 1, Schrems 2, etc., they would not allow non-European entities to process European data. So I think India is trying to do the same thing, just going one step beyond, as you said, also in the case of data sovereignty and security, in trying to protect its security more than anything else. And actually, in the Joint Parliamentary Committee, you can see that the report by the Joint Parliamentary Committee, you can see that one of their concerns is exactly that, is security. They mention the exploitation of Indian data by non-Indian actors, by terrorists, etc. And they want that to not happen. Though, of course, I think another concern would probably be, an evidentiary more than anything else, the access to evidence in other countries for criminal procedures, which is something I think, which is one of the reasons why even if non-critical personal data is being processed outside of India, the law requires that a copy of that data be kept in India anyway. I think that's primarily for criminal processing rather than anything else.
Very interesting. Ketan, I mean, it's probably a coincidence, but it's an important coincidence that this debate on the law is in parallel with two major crises in the world. The one is obviously COVID, and the other one is the war. Now, at least from a European perspective, it's a major crisis in the world. I don't know whether it's from an Indian perspective the same picture. That would also be interesting, by the way, how the war is monitored in India on the streets at the moment. But for us, it's obviously a major crisis. And my question then would be a major global crisis. And my question would be in how far this debate on the data protection reform package is in a way influenced by the COVID and or the war situation, in particular when it comes to issues that you already mentioned, such as security on the first hand, and also controllership and keeping things under control. Yeah, let's put it like this. Is there such an influence, or is it just a coincidence that this is happening in parallel?
To some degree, perhaps it's a coincidence because, as I said, the first judgment that talked about the right to privacy came out in 2017. Yeah. And the first bill on the data protection, the first personal data protection bill was created in 2019. And the Joint Parliamentary Committee, as I said, was actually debating over this bill over the COVID-19 emergency. So I do believe that while the 2019 bill was obviously not informed by the COVID-19 emergency, the Joint Parliamentary Committee's response to that bill was shaped by this global pandemic. And you can see some influences of that because of the focus on health data. So one of the things that's happened recently is, and we can perhaps talk about responses to COVID by the Indian government as well here. Yeah. One of the things that happened was, of course, a contact tracing app, like most countries, was developed in India called the Arogya Setu app. Technically, I mean, the translation is Bridge to Wellness, Arogya Setu, the app. It was developed as a contact tracing app initially. And several issues were raised about data protection concerns about this app, just because there is no real data protection law in India. So even though other countries might also have come up with a contact tracing app, they might have also had a data protection law, but India did not. And of course, that's a concern. So you can see that the policy in India was actually quite fragmented when it came to this contact tracing app. There is a specific privacy policy that relates only to the Arogya Setu app, to the contact tracing app. And it was issued along with the app and has been extended. It was first issued for 6 months, and then it kept being renewed by notifications from the government. So that's how that data is being managed. So they did see that there was a need to have a privacy policy in place for all of the data that the government was collecting through this app. So definitely this was influenced by the COVID-19 emergency.
And did the app work? I mean, did it fulfill its purpose? Was it fit for purpose?
There are hardly any studies about this, about whether it was useful. There were I think this is probably going to be more of a post-mortem sort of analysis than something that would be happening while it was going on. But it's difficult to understand if it was useful in any way, because the way that the government responded to the COVID-19 emergency was primarily through severe lockdowns. So when the government first started being concerned about COVID-19 was in January of 2020. And state government, so India is a federal structure. There's a central government, and each state within the country has its own government. So you could see that there were state government responses from about February to early March of 2020. But then the central government came in and instituted a nationwide lockdown, absolute, complete lockdown that was supposed to be in the beginning for 2 weeks, I think, but was then constantly extended up to May. So 2 or 3 months of a severe lockdown. So of course, I'm not sure how a contact tracing app would have helped when everyone was at home.
Yeah.
And several cities like Mumbai, Delhi, the big ones, had their own localized versions of lockdowns going on for months on end. So it's difficult to see how many of the steps that the government took to curb the pandemic actually panned out. But we can see that many steps were taken, and one of the unique things that happened in India was that COVID was actually not that bad in 2020. So many of these steps were seen as being successful. The contact tracing app, the lockdown, etc. And by early 2021, the government had mostly given up, or people had mostly given up on, restricting their movement, on stopping the spread of the pandemic in any way. And then that was when the real pandemic began in India. It was, I think, March of 2021 that the second wave of the pandemic began, and then everything went crazy. There were huge lockdowns. There was a huge shortage of oxygen, of medicine, etc. If not shortage, then there was a problem with supply, etc. So there were different measures taken then to ensure that supply was adequate, to ensure that there were no bottlenecks. You could see that each state then issued its own lockdown, which meant that in order to pass between across state boundaries, across state borders within the country of India, there were problems. So there were, thousands of people stuck at the border because they could not cross over. So there were a multitude of different problems that arose during the pandemic that go beyond data protection.
Yeah.
And it became not as big a concern. I mean, people didn't care so much about data protection when things were going so haywire.
Yeah.
One of the things that you can see happening on the ground was, for example, delivery. Most people were not going to shops or to restaurants themselves. They were ordering them via delivery apps, right? So you could see private entities, the delivery apps, actually instituting measures to stop people from panicking. So one of the measures that they instituted was these apps would show you the vaccination status and the most recent skin temperature of your delivery guy, of your delivery driver. And this was normal. So if you open the app, you ordered something, you could see the name of who was delivering your food or whatever you wanted, their vaccine status, and their most recent body temperature. And so you can see that privacy was not a real concern in most people's minds. They were thinking more about stopping the pandemic from spreading.
Yeah.
So it was something that I was shocked when I recently went to India. So across most of the pandemic, I was stuck in Europe. I was stuck in Malta. But then I recently went to India for a couple of months, and I saw that many of these things were just normal. No one even commented on the fact that their vaccine status, their biometric data essentially was publicly available on a private app, not even a government app, and keeping in mind that a personal data protection law does not really exist in the country. So there are several different concerns when we're talking about the pandemic and India. Many that are very interesting to study now that most people have stopped caring so much about the pandemic across the world, and definitely in India as well.
And do you think that, I mean, when you look into the perception of such factors, such as having biometric data of your delivery driver on your app, is perhaps, at least from a European point of view, a little bit weird? Is this something which is, which was not seen because of the catastrophe of the pandemic as an issue, or is this culturally so different from Europe that people do not really see this as a problem?
So I guess it's a bit of both. Definitely, the pandemic made people be far more wary of talking to anyone who they did not know whether they were vaccinated or not. So this made it far more okay for this data to be on private apps like this. But definitely culture plays a role. And this is actually something that I was studying as part of my PhD research. Which was focused on identification systems, but also looked at the cultural aspects of attitudes towards identity systems. So one of the things that I found was that and I collected data on this. I asked people basically about whether they have an ID card or an ID number, whether they use that ID number or card to access some services. And to what degree are they okay with having mandatory ID systems to access welfare in India? So one of the clear responses that I found from Indians was that 95% of my respondents were in fact in favor of an ID card being mandatory for access to welfare services. And many of them were actually okay with the government having their data as long as they knew what the government was doing with their data. And so one of the things that I've seen in India is definitely we're far more accepting of data being collected than, say, in Europe. One of the things that you can see, one of the clear forms of evidence of this is in the Aadhaar card, so the national ID card. The data for that national ID card had begun to be collected in 2009 or 10, but the law that actually implemented this card was passed in 2016. So essentially, the government was collecting data from most of its citizens without a data protection law in place, without a law in place even legalizing the ID card. And almost 1 billion people had gone ahead and given their biometric and personal data to the government to create this card. It's something, it actually was the thing that, it's actually what began my interest in culture as being so important for privacy. And one of the ways that I explained my research earlier was to basically show a picture of Indians standing in line to give away their data for the Aadhaar card, versus on the other hand, say in the UK, where there were protests against the ID Act in the first decade of the century. And it was such a clear, stark difference, cultural difference between Europe and India, in the sense that Indians are far more okay with giving away their data as long as they're getting something out of it. That's important. And that's something that I think is very important for future research as well. As long as you see that some welfare benefit will be granted, most people will go ahead and give their personal data and sensitive data away without there being a law in place protecting that data. So one of the successes that have been touted by the Indian government is what they call the JAM Trinity, which is the Jan Dhan, Aadhaar, and Mobile Trinity. To give you an explanation, in 2014 or 15, there was a rollout of a scheme to get as many people banked as possible, to open bank accounts for as many people as possible. So that was through the Jan Dhan, is what they called it. The Aadhaar was the national ID scheme. That's the second one. And the third one is mobile. So access to mobile phones in the country. And this trinity of schemes is seen as one of the great successes of the last decade, because it allowed the direct transfer of welfare and benefits to people from the government.
Mm-hmm.
And the reason why it was such a huge success, I think, was because also of the culture of India. Where most people went ahead and gave away whatever information was needed in order to secure that bank account, the national ID card, and to get a mobile phone.
Mm-hmm. Mm-hmm.
And you can see that the culture has not shifted despite the pandemic even now, because the Indian government has come up with this national health scheme through which it intends to create a health ID. Through this, the same app, in fact. So the Arogya Setu, the contact tracing app, has now morphed into an app that can issue you a health ID number. And this health ID number is something that would allow people to transfer their medical records from, say, one health service provider to another. So the culture persists, and the government initiatives that focus on collecting as much data as possible also persist. And this is, very different from what I've seen happening in Europe.
Yeah, sounds like a very, very positive plan for someone who really wants to collect a lot of data of a lot of people for whatever purpose, right?
And then commercialize it as well. So the government is collecting this data and then blatantly creating a policy that will allow for the commercial exploitation of this data. Anonymous data, apparently, but that's one of the protections that they've given in the policy, that the data is going to be anonymized. But as we know, data anonymity is not really something that exists when you have a huge data set. It's easy to get to re-identify personal data from anonymous databases, right? Someone is very happy that all of this data is collected, and then they're also happy to commercially exploit it.
Wow. Okay. So there's plenty of work for for people like you monitoring this and assessing this in the next weeks and month. Are you going to write on the Indian data protection situation in the near future?
Absolutely, it's on the cards, especially because of my interest that began with the national ID system, and now is being extended through the health ID plan that the government is coming up with. I expect to write a lot on identification and privacy in India.
That's very interesting. Also, the health part is very interesting because also from a European perspective, obviously, because of this huge effort now from the Commission to build up this European health data space. There was a draft regulation just presented recently that is obviously the very European approach to this. Let's collect a lot of data for health-related purposes, and let's think about this more from a structural point of view. So there will be plenty of things to compare. So it's not just COVID and not just COVID-related apps that we need to discuss in the near future. And I'm afraid we also need to discuss a little bit more in the future about how dealing with the pandemic per se. And whether there are any significant culturally driven differences between the European and, for example, the Indian approach.
And of course, it's not just about privacy, right? There are so many human rights being impacted by the pandemic.
Yeah, absolutely. Absolutely. And probably one could already discuss, you could also discuss about which human right is the proper basis in your legal culture for the development of privacy and data protection. In Europe, it would be human dignity that would probably, at least the German speakers within the European Union, mention first here. Whereas in other areas of the world, there are other fundamental rights that play a role here. And I would assume that dignity is probably not the first one that you would think about from an Indian perspective when talking about roots of privacy. It's liberty, right? Yeah. And it's the right to be left alone, not the right, to develop your personality more, probably, right?
Actually, so if you read the judgment, the 2017 judgment by, in fact, Justice D.Y. Chandrachud, one of the things he mentioned was, in fact, linking privacy to personality.
Yes.
That the right to the development of your personality then includes the right to privacy. So they're trying to take both approaches in India.
Yeah.
Let's see how that works,
Yeah.
because we know that the US that the US approach is more towards consumer protection.
Yeah.
Sorry.
All good. No worries.
That the US approach is more towards consumer protection.
Yes.
But India is not actually going that way. It's
Yeah.
going more towards the European way of having an omnibus right to privacy that is constitutionally guaranteed, rather than through a set of a fragmented set of policies.
Yeah, but if that were true, then the state surveillance would be an important part of the picture, obviously, right?
Yes.
I mean, in Germany, it was the first part of the picture historically, because of the fact that it has something to do with dignity, right? And
actually, in India, the reason why, and I'm absolutely not an expert on this, but one of the things that I have seen is the reason why the Indian government is so keen on excluding, say, the intelligence function or law enforcement from these laws is because it sees itself as being in an undeclared state of war, basically, against Pakistan, against terrorism, against China in the north. And so I think that they see themselves as being, as any restrictions on their ability to carry out their role towards the protection of India from foreign actors as being untenable. They do not want any restrictions at all.
Yeah.
And I don't think the government is going to change this stance ever. I mean, this has been the case since independence for India. It's not unique to the new government. Most governments have been concerned about security and have not seen any restrictions as being good to the protection of India.
Yeah. That is very interesting, Ketan, and I'm quite sure that we will have a follow-up discussion on this. If I may, I will invite you again in half a year or a year to further develop on these things when we see a little bit more clearly about what the law is going to change, and also what the pandemic and the autumn within the pandemic will change. But for today, I would slowly come to an end, if you agree, by asking you the usual question that I always ask, which is, have I forgotten anything? Is there anything that you want to cover that I should have asked you?
Thank you so much for inviting me, Nikolaus. As I said before, I don't think there is anything, in the broad strokes that is left when we talk about privacy and the pandemic in India. But of course, as I said, the policy space in India is moving pretty quickly over the past couple of years, and we hope to see many changes in the coming years. If not the current bill, then perhaps a new bill that takes all of these safeguards into account, that doesn't give the government such broad sweeping powers and exceptions to its own laws. Let's see how that goes.
Yeah. And
it'll be a very interesting discussion in the next year or so.
Absolutely. And let's talk again then, if I may. This is a serious invitation already now that I would really like to follow up this with you, Ketan, if I may.
Absolutely. Looking forward to it.
Wonderful. Thank you for the moment, Ketan. Thank you to our audience for listening. Please stay in contact with us, stay interested, and in particular, stay as healthy or become as healthy as quickly as possible. All the best to all of you. Take care and hope to see you soon. Bye-bye.
Bye-bye.